Hello, everyone. Let's begin discussing MTP, which has been released for December 23 examination. That is, MTP that I'm discussing is, of course, the set one. Right. So, we are going to have a quick discussion on the entire MTP, including objective, descriptive, all types of questions. And in between, I'm also going to give you some tips and tricks for writing descriptive answers. Okay. So, let's begin this now. The very first question, section A, MCQ. All the MCQs are of 2 marks each. The very first MCQ, ABC Limited has 35% shares in XYZ Limited. The majority of directors of XYZ Limited are appointed and removed by ABC Limited. That means over the directors, this particular company has full control, right? XYZ Limited is what? Is it a subsidiary? Is it not a subsidiary? Now, when we look at the definition of subsidiary, Section 2, Clause 87, which we read in the very first chapter, Company Formation and Conversion, we have two criteria. Subsidiary and holding is a relative concept, right? So, a company will be a subsidiary if its holding, right, controls the composition of board of directors or holds more than 50% of voting power. So even if it is 50.01% of voting power, it will still be called as subsidiary. Although this particular company doesn't fulfill this particular criteria yet, since the majority of directors are appointed and removed by ABC Limited, that means it is completely controlling the composition of board of directors, and hence XYZ Limited can be completely and absolutely called as the subsidiary of ABC Limited. So, what will be our correct answer? It will be option A. Moving to the second question. Once a dividend is declared in AGM, dividend may be revoked, cannot be revoked, may be reduced, payment can be delayed. See, it may be reduced by the members after recommendation of board, not after declaration. So once a dividend is recommended by the board, the members may reduce the rate, right? And thereafter, whatever rate they settle down on, and the dividend is declared. So once it is declared, it cannot be revoked. It becomes the liability of the company and has to be paid within 30 days. If it is not paid, then there are consequences of section 127, right? So it cannot be revoked. Question number 2, the correct answer is cannot be revoked. Moving to question number 3. Under IBC, where extension of time is requested. Ideally, this question is not technically completely correct, but I'll tell you why do you answer what. The CIRP shall be completed within a period of. See, the normal period for completion, the time limit for completion of CIRP is 180 days. However, you may be granted an extension of 90 days. So if you add 180 plus 90, that comes out to be 270 days, and we don't have that in our option over here. Right. So where extension of time is requested or where extension of time is granted, then it could amount to 270 days. But here we don't have that an option. So the general time limit for completion of CIRP is 180 days from the admission of application. So what will be our correct answer over here? It will be option C, 180 days. Okay. Corporate governance practices are almost formalized or regulated or accepted or rejected. See, in India, definitely we can say that the corporate governance practices are being increasingly regulated because people don't follow what is not being told to them, right? So, SEBI has introduced a lot of regulations which the company must follow. It is mandatory for them to follow. So all the corporate governance practices of the proper governance practices, because they could adversely affect a lot of stakeholders. They are being regulated. Okay, so yes, we cannot specifically say that they are being regulated by companies, but they are regulated by the lawmakers, by SEBI, by the authorities with respect to companies. However, with a slight error in language, we consider this to be our good, appropriate answer. Moving to the next one. The recommendation of audit committee may be accepted, may not be accepted, has to be accepted, Recommendation need not go to the board meeting. If key is not accepted, board has to record the reason. See, whenever we read about audit committee, it has a certain role to play. And whenever its role comes into play, it has certain recommendations to make, like the recommendation of name of auditor. So if the name of auditor is being suggested by the audit committee, the board may like it, may not like the recommendation. What they do is, they audit committee, you recommend a name to the board will look at your recommendation. If they like it, they will proceed and recommend the same name to the members, and thereafter auditor may be appointed. If they do not like your recommendation, they will refer back the recommendation, and then you will reconsider it. If you decide not to reconsider and still there is disagreement between audit committee and the board, they do not come to a consensus, the board will record the reasons why you did not accepted the recommendation. Okay, and they have to disclose that in board's report. So question number 5, the correct answer is option C. In case not accepted, board has to record the reasons. Okay, moving to question number 6. At the time of IPO, the issuer has to have a, see, whenever we read about IPO, that is CBI-CDR regulations, IPO is very, or I would say this particular topic is very important. At least one question is definitely asked in examination, either in the form of objective or in the form of some short note or subjective type of question. And in this, we read about first IPO eligibility, who is eligible. There we have a lot of things about promoters, etc. Second, we read about appointment of merchant banker and other intermediaries. Right? So you have to have a merchant banker and other intermediaries who are registered with SEBI. At the same time, you also are being told to appoint a designated compliance officer. What for, ma'am? Who is actually responsible for monitoring the entire process and also addressing the grievance of investors. Right? So issuer must have designated compliance officer for the same. Question number 7. SEBI has 3 functions rolled into one body. Which of the following is not the function of SEBI? See, why is it written CASI? CASI is what? CASI is, you can say, partly. It has some attributes of legislative also. Why? Because it is the lawmaker. SEBI makes a lot of regulations. So SEBI makes law. It has some attributes of being judiciary body also. Why? Because it is definitely a quasi judicial body, partly a judicial body. Why? Because it has the powers of adjudication. SEBI imposes a lot of penalty, just like the courts can do that, right? At the same time, SEBI is also an executive body. Why executive? Because it ensures, it is responsible for the execution of law which has been made. So it monitors also that, right? So legislative, executive, judicial, right? Definitely all the 3 functions rolled into one body. What is not present is the last one, quasi official. So this is going to be our right answer. Okay. Moving to the next question, the Competition Act has replaced. I don't think I need to justify this answer at all. We all know this very well, right? What is the correct answer? It is definitely MRTP Act. So earlier we had monopolies, restrictive trade practices. Now they have been all rolled into the Competition Act, where such type of practices have been prescribed and adequate actions have been stated. Question number 9. Zenith Limited is a company registered in UK. So there is a company incorporated in UK, company incorporated outside India, that issues shares to resident of UK only. How are we considered? How are we involved over here? Is it a foreign security? The answer is no. Had it been a foreign security, I would have been a PRI. Maybe a person resident in India is acquiring some shares of a company incorporated outside India. So that is treated as a foreign security, right? Indian security. What we are concerned about, we're not concerned about if there is a company incorporated outside India who is issuing shares to somebody outside India only. How are we considered? How are we concerned about the same? So none of the above. Okay. Now, according to Banking Regulation Act, again, this line holds a lot of importance in this particular act. I hope you remember the section number also, section number 15. No banking company shall pay dividend on its shares until all its Depreciation is fully written off. Well, that goes without saying that the language doesn't match. Capitalized expenses have been completely written off. Bad debts are provided in full, or contingent liability is settled. So the answer is capitalized expenses have been completely written off. Ma'am, what are capitalized expenses? See, whenever we talk about preliminary expenses or the brokerage or the commission that you have paid on shares, they are all the expenses capitalized, right? So unless they're completely written off, a banking company cannot pay dividend on its shares. Okay. Now, a unit has investment in plant and machinery of 55 CR and turnover of 300 CR. It will be classified as what? Micro, small, or medium? Well, if you try to recall, ma'am, why is it not working? Ma'am, if we talk about micro, we can say that, or let me write it this way: plant and machinery and turnover. Investment in plant and machinery should be less than equal to 1 CR, and the turnover, and there is twin condition compliance, and the turnover should be less than equal to 5 CR. If I talk about small, right, the plant and machinery should be less than equal to 10 CR, and the turnover should be less than equal to 50 CR. If I talk about medium enterprises, the plant and machinery or investment should be less than equal to 50 CR, and the turnover should be less than equal to 250 CR. Ma'am, the investment is 55 CR and the turnover is 300 CR. So it does not fall in this category or this or this. That means, can I very well conveniently conclude that the correct answer to question number 11 is D, none of the above. Okay. Now we come to the next case study. ABC Limited. We have a case study based MCQ. ABC Limited is a company which has a paid up capital of 50 CR and a turnover of 300 CR. Fine. Mr. Rajesh Kumar, who is promoter and MD of the company. Now, in such type of question, when you get a case study based MCQ, it is very important to know what is the requirement. Because unless you know the requirement, this is not a very huge case study. I would say it is just this much. But sometimes you get a very elaborate case study in which the facts or the figures may not be important, may not be relevant for the questions given below. So have a quick view of what is being asked, right? See, which statement is correct? Okay, independent director, okay, woman director, okay, status of director. So it is more about directors. Okay, fine, ma'am. And we all know about the requirement of directors. What is the requirement of directors? Ma'am, section 149. First of all, tells us if it is a private company, you need to have minimum 2 directors, and if it's a public company, you need to have minimum 3 directors. The maximum is 15, which can be increased by passing SR. Okay. So since it is a public company, I would say a public company must have a minimum of 3 directors. Minimum of 3 directors. Right. And out of which, of course, there should be 1 resident director also. This is a basic requirement of every public company. Thereafter, we have the requirement of woman director, and we also have the requirement of independent director. So we have different category of companies in which woman director is mandatory or independent director is mandatory. So we have that different conditions. Okay. ABC Limited is a company with paid up capital of 50 CR and turnover of 300 CR. For all those who remember the limit, will be primary facing, be able to identify that you need this. Okay. Mr. Rajesh Kumar, who is promoter and MD. So we have Rajesh, who is the MD. So director number 1. Wants to run the company complying with all the rules and regulations. Okay. Chairman is a non-executive and is an eminent academician. Okay, so we also have a chairman, and the chairman is non-executive director. Okay, there are 2 more directors. One is director finance, Mr. Joshi. So we have Mr. Joshi and Mr. Nirmal Kumar. Mr. Nirmal Kumar. So prefix of all the names is Mr. So I can conclude that all the four people over here are male directors. Yes, Mr. Nirmal is also related to promoter. Okay, it is written that he is related to promoter. Now, company is proposing or is in the process of taking some loan from SBI, where SBI will nominate a director. So we will have another director on board, which is going to be nominee director by SBI. Okay. So we will have in total 5 directors on board after SBI nominates the same. Now we have been asked certain questions. Okay. In the present board properly, is the present board properly? Which statement out of the four is correct? See, one thing which I am very well able to relate and identify is that the requirement of woman director. See, I'm erasing this for a while. When I talk about woman director, for every listed company, you need a woman director. Plus, even if it is unlisted public company, but the paid up capital is more than equal to 100 CR. Okay. Or the turnover is more than equal to 300 CR. What do you need? You need a woman director. So in this case, the turnover over here is exceeding. The turnover exceeds 300 CR. So definitely this particular company needs a woman director. The paid up capital is within that limit, but the turnover exceeds 300 CR. So you need a woman director, and this particular company has not appointed any woman director on board. Okay, ma'am. Company is an unlisted company with 4 directors. The present board is properly constituted. Wrong. Company is an unlisted company with 4 directors, which is properly constituted. But since the turnover is more than 300, this seems to be correct. Let's read the 2 other options also. Company is an unlisted director with 4 directors, which is properly constituted, but need of 1 resident director who has stayed in India. No, we haven't been told that these are non-residents. So everyone, unless told, looks like resident only. So this statement is incorrect. Company is an unlisted company which is properly constituted with MD. Again incorrect. So what is our correct answer? This one. Option B. Option B. Okay. Next. Can Mr. Nirmal Kumar be considered as an independent director? Well, no. When we look at the criteria of independence, we know that a person who is the whole-time director of the company or nominee, he cannot be an independent director. Somebody who is the promoter, who's related to the promoter, who's having some pecuniary interest, who is a relative, who is relative is a KMP in that company or holding, they cannot be independent directors. So we have a huge list of criteria of independence, and definitely if you're related to the promoter, you cannot be called as an independent director. So yeah, no. Can Mr. Nirmal Kumar be considered as independent director? The answer is no. Why? Since he's related to the promoter. This is going to be the correct answer. Next. Is there any need of woman director? 100% you need woman director. Why? Because your turnover is more than 300 CR. So this we have already established before. What will be the status of director nominated by SBI if she is a woman? She will be a nominee director. Well, a woman director, we don't have any status as such, right? So if a woman is being appointed as a nominee director, she will be a nominee director. Simple. Okay. Sometimes the answers are so simple that we get, oh, really? This is only the answer. Fine. Now we come to section B. Section B. So, of course, you have been given a choice over here, but we are going to discuss all the questions. So, out of 7 questions, you have to answer just 5, but choose the best possible answer first. So, whatever you know your best, choose that particular answer and give your best shot. Ma'am, will it help? Does it really help? Yes, it does. Once the examiner has framed an idea about your knowledge, they will judge you accordingly, right? If your first answer is clumsy and it spoils the mood of the examiner who is evaluating your answer sheet, right? So give him a good smile. Give her a good smile and thereafter begin with the paper, right? So Yes, the first answer holds a lot of importance in your paper. So, whatever is your first answer, you have to choose it wisely. Okay. Describe the classes of companies which are outside the purview of Company Auditor Report Order CARO under Companies Act 2013. Now, all you have to do is list the companies which are outside the purview. How are you going to do that? It has to be in points 100%. Okay, so what are going to be the points? You have banking company, you have banking company, you have insurance company, you have section 8 company, you have OPC, thereafter you have small company, and you also have private company. What is small company? That also you must define, because when we read caro we read it that way only, right? So when you're writing banking company, it has to be the banking company according to banking regulation act, insurance company according to insurance act, right? Section 8 company which is formed for charitable object. So whatever you're writing, you have to elaborate these points properly. And the last point, private company, if it satisfies certain criteria. What is the criteria? There are basically four criteria which a private company has to satisfy to be exempted from this caro reporting. What is it? You should not be holding subsidiary of a public company. So you should not be a holding subsidiary of a public company. Secondly, your paid up capital plus reserves should be less than or equal to 1 CR. That means it should not exceed 1 CR. It should not exceed 1 CR. Okay. Thereafter comes your borrowings. Your borrowings should also not exceed 1 CR. And your revenue, total revenue should not exceed 10 CR. So if you satisfy all these conditions, then of course you don't have to do that caro reporting. You're exempt from the same. Okay. So how are you going to write the answer? In points. Elaborate these points. Write them in your own words. What is the problem? As long as you're writing this context correctly, you will be getting the answer, getting the marks. Don't worry. Okay, ma'am. Moving to the next question. Question 2, part B. Summarize the disqualifications of directors. So, disqualifications, we have these two disqualifications, section 164.1 and section 164.2. When I talk about section 164.1, what are the disqualifications? Ma'am, somebody who is of unsound mind is disqualified, somebody who is undischarged, insolvent is disqualified, somebody who has applied to be adjudicated as insolvent is disqualified. Somebody who has been convicted for an offense, it doesn't matter whether it involves moral turpitude or not, but somebody who has been convicted of an offense for imprisonment, at least 6 months, and thereafter, after his expiry of sentence, 5 years have not elapsed, right? So 5 years, till 5 years he will be disqualified only, right? If you have been convicted for offense with respect to related party transactions, if you have been convicted or if you have not complied for the limit, section 165, which states that the maximum number of directorships that you can hold, okay, if you have not complied with the din provisions, right? So, unsound mind, undischarged insolvent, applied to be adjudicated as an insolvent, convicted, imprisonment for not less than 6 months, and a period of 5 years has not elapsed from the date of expiry of sentence, convicted of an offense dealing with related party transactions, not complied with section 152, which relates to din. Okay. Not complied with section 165, which relates to maximum number of directorships that you can hold. Okay, so these are all the disqualifications which are being stated in section 164.1, right? These are some additional points with respect to the above disqualifications, that when this will not take place If you make an appeal, then of course the disqualification shall not take place unless the appeal is disposed of. So this is an additional point which you may remember to write, which you may not remember to write. So I'm striking this off. If you're just asked about the disqualifications of appointment of director, even if you don't write this, you should get marks. But of course, when in your examination, the I wouldn't say, or I would say, it is somehow disheartening to see that there is a particular topic and you have been asked a question for maybe 8 marks. I'll show you. I think there is one question like, what is the role of RBI in FEMA? It is, the question says in FEMA. Now, in FEMA, you have read a very limited role of RBI. Of course, RBI has a huge role, but that has not been elaborated properly, right? So, what they have done is they have framed that question of 7-8 marks, and thereafter they have written the entire thing: role of RBI in PMLA, role of RBI in granting license to banks, role of RBI in Banking Regulation Act. Everything they have written in the answer. So sometimes it is the harsh reality that you need to elaborate your answers because the weightage is so huge that you don't have the sufficient content to justify that marks, right? So if that is the case, then go on and write it. Otherwise, you don't need to write this. But definitely you need to write this particular part also. So if you have been a director of a company which has not filed, so you have been attracted the disqualification because of company's failure to do something, but as you were a part of that particular company, you were responsible for doing that filing. If you have shown that irresponsibility, then you cannot be a director, right? Okay. Now, who has not filed financial statements or annual returns for continuous period of 3 financial years, or has failed to repay the deposits, interest, debentures, interest, dividend declared, preference shares, or and such failure to redeem continues for 1 year or more, then you become disqualified. However, such disqualification shall not incur the disqualification for a period of 6 months from the date of appointment. What does that mean? If you are a new director, you're being appointed and you come to know that this particular company has not filed financial statements for consecutively 3 years. Now I am disqualified. No, no, no. You have just joined the company. We should give you the time to adjust, to rectify the situation, position, whatever it is. Right? Okay. So for the initial 6 months, you're not disqualified on this particular ground. I hope that's clear. Okay. Moving to the next question, question number 3A. A casual meeting of the directors, even at the office of the company, cannot be treated as board meeting. That's true. That's completely true. Why it cannot be treated as the board meeting? Because board meeting also has a lot of compliances to do. We have a section called as section 173 under Companies Act, which talks about board meeting. Okay, so it talks about the meeting of the board. What broad things that you must incorporate in this answer are: minimum of 4 meetings of the board of directors need to be held in a year. Meeting, there should not be a gap of more than 120 days between 2 consecutive meetings of the board. So 2 very important things first. Okay. First. Second, how a meeting may be done. Meeting can be done in person also. It can be done through video conferencing, that is AV means also. This is the second important thing that you must write. Okay. So, directors can participate in the meeting either in person or through AV. Earlier, there was a condition that some matters cannot be taken up through AV mode. Now, we don't have any such thing. Right, so anything and everything can be discussed through AV mode. That is not the problem. Moving to the next part, next very important thing is about notice of meeting, and you have to write the entire thing about notice of board meeting. So whenever a board meeting has to be called, it will be called by giving a notice, minimum 7 days to the directors. Right, these are the modes by which notice can be given. However, if you want to transact some urgent matter, then at least one independent director must be present in the meeting. right? If he is absent, the decision will be circulated to all the directors, and if at least one independent director approves it, then it is going to be valid. It is going to be valid, right? Okay. If you do not comply with the provision, then of course the penalty gets attracted. Now, you also have to write about the quorum. What is the quorum? One third or two, whichever is higher. That is going to be the quorum of board meeting, right? Okay, ma'am. So there are some things more about the quorum. If you remember, you write it. If you don't remember, you don't write it. But whatever the content I have highlighted, you have to write all these points and elaborate the same, right? Now we come back to, we have, see, the question states that analyze the legal provisions relating to board meeting. So you have to analyze all the legal provisions that you know with respect to board meeting. So how a board meeting can be called, how many times a board meeting has to be held, what is the quorum in board meeting, what is about the notice in board meeting. You also must write about the agenda. Okay, so also write about the agenda of board meeting. Okay, that as a part of good secretarial practices must be sent, etc. Everything. Now, lastly, you will also add a conclusion, which generally institute suggested answers don't. But you must add a conclusion. What is the conclusion that you will add? That since all the compliances have not been done with respect to board meetings, we cannot consider it as a board meeting. Okay. Now, question 3b. Who shall bear the cost of investigation under section 225? Now, section 225, very a simplified section of investigation. See what happens if a person has made a complaint. If a person has made a complaint about investigation, and investigation is carried out, I'm talking in general, if investigation is carried out, and then we come to the conclusion, oh my God, there was a need of investigation, this particular person is found guilty, right? Actually, the prosecution starts and he is going to be found guilty. So now, this person bears the cost of investigation. However, if no prosecution could be initiated because after investigation you come to a conclusion that this particular person is not guilty, then who will bear the cost of investigation? The person who filed the complaint. Simple. Going by the same logic, section number 225 has been framed, which states that when central government is going to carry out the investigation, at the very first place, CG pays or CG bears all the expenses of investigation, but it is going to be reimbursed by whom? The person who is found guilty, who's convicted, that means who's found guilty on a prosecution instituted. So whenever the trial begins and a person is found guilty, then such person shall be ordered to pay, who is ordered to pay damages or restore any properties. He will also be ordered to pay such expenses, whatever the court specifies, right? Whatever the court specifies. And the company or the body corporate, here we are talking about the individual or the person, here we're talking about the company or body corporate, whoever has got any sum or property they have recovered, whoever was involved, fine. Because what happens when we're talking about a fraud, there are two people who gets benefited. One is the company eventually hasn't done any fraud, however the people behind the company have done the fraud, so they will be liable. But at the same time, the company has got some benefit, whatever value you have recovered, whatever profit you have made, whatever sums you have made. From that particular sum, of course, this expenses can be met out. However, if no prosecution is instituted, if a prosecution is instituted, these people will pay the cost of investigation. If it is not instituted, then what is going to happen? Then whatever the company, body corporate, MD or manager is reported by the inspector, they are going to be paying, and whoever applied for investigation. Okay, so they will be responsible for reimbursing the cost of investigation, because at the first place the cost of investigation are going to be paid by central government only. Now, Moving to the next question, very easy one. Again, a question on board meeting, and some part of board meeting we have already discussed, so it will take us less time to elaborate the answer. Three board meetings. Three board meetings, that means if I make a timeline over here, the first board meeting on 1st January 2022, which falls in separate different financial year. Second board meeting, 1st April 2022. Then 1st July 2022. And there was a fourth board meeting, 27th October 2022, which was adjourned to 3rd November 2022. Okay. So we have been given these dates, and we have been asked that has the company contravened any provisions of Companies Act 2013? Well, I'll take you back to something that we have just discussed. Very important provision: number of meetings to be held, number of board meetings, right? The first meeting of the board shall take place within 30 days. So, this is the first thing. But here we are not talking about a new company being incorporated. So, we are not concerned about that particular point. After the first meeting, a minimum of 4 meetings of the board of directors need to be held in a year. So, 4 meetings every year. The section further states that the meeting is to be held in such a manner that there should not be a gap of more than 120 days between two consecutive meetings. So, all we have to check over here is point number 1: within incorporation, 30 days, that point is irrelevant. Second, minimum 4 meetings, and third, gap should not be more than 120 days. If it falls within that parameter, then then of course there is compliance and no contravention. If it doesn't, then definitely there is a contravention. So here, coming back, as we can see that there are 4 board meetings held in year, right? First, second, third, and fourth. Right. Ma'am, why are we not considering this to be the 5th one? Because this is an adjourned meeting, and adjourned meeting is nothing but a continuation of original board meeting. Right. So this is not a board meeting. We can conclude that the company has held 4 board meetings during the calendar year 2022. Right. Okay. So first condition is complied with. Now we need to check the gap. The gap should not be more than 20 days between any 2 board meetings. So we have to check the gap. So if you look at this, 120 days means what? 120 days is broadly 4 months, right? The gap should not exceed 4 months. So if it is held on 1st January, that means Jan, Feb, March, and okay, it's not more than 4 months, fine. Then April, May, June, it's fine. July, August, September, and before the October ends. So here also we have complied with, because this is the relevant date that we will consider and not this date. This is the date of board meeting. This is not the date of board meeting. And this is only the continuation of original board meeting. However, if there is any resolution which is passed, that is a different thing, that we consider it to be passed on that particular date and not on an earlier date. However, in general, what is it? That this is going to be the date of board meeting. Okay, so can we conclude that A Limited has not contravened any provisions? Yes, ma'am. A Limited has completely complied with the provisions of section 173. Okay. Now let's have a look at the next question. Where is it? X and company is LLP firm. So it is an LLP, wants to convert their firm into a corporate entity as per the provisions contained in section 366 of Companies Act 2013. So we read about company formation and conversion in the first chapter, wherein we read about conversion. Conversion of what? LLP into company and company into LLP. So when you want to become LLP, the provisions are contained in LLP Act and there are scheduled for the same. But when you want to convert LLP into company, the provisions are contained in section 366 of Companies Act. Fine. And it is of course read with the relevant rules. What are the relevant rules? Companies authorized to register rules. Okay. So, LLP, you have conducted a meeting for conversion and you have decided the name of the company summoned for the purpose of registering LLP. In the meeting, 1/4 of partners want for conversion into a private limited company, and 3/4 partners want a new corporate entity with the word public limited. There are 6 partners in the firm. Recommend the appropriate decision and steps to be taken by the firm. So, what all things you have to write over here? First, try to understand that. What is the procedure for conversion of LLP into a private company? Okay, because there are only 6 partners in the firm, you cannot be converted into a public company. For conversion into a public company, you need to have 7 partners. Although, if I take you through prima facie, conversion of LLP may happen into a private company or into a public company, and these are broadly the steps of conversion. You need to have approval from all the members. You need to have give an advertisement in newspaper seeking the objection. You have to obtain NOC from ROC where your LLP is registered. Thereafter, you fill the form for name approval. Your name gets reserved for ideally it's 3 months, I would say, or let's not get into that part. Thereafter, you have to file the form URC1. So, what is URC1? URC1 is a form, and there is which has to be filed by the applicant when we are talking about this particular conversion. And there are certain details that you need to furnish along with URC1. See, the first step is to obtain the approval from all the partners. Thereafter, you also need to obtain your name. So you reserve a name. Ideally, it is reserved for 3 months. But as I said, let's not get into that. You have to reserve. You have to remember that it is reserved for 60 days. Fine. So keep that only in mind. Right now, it's the time not to confuse you. Okay. Thereafter, what happens, ma'am? We file a form. Right, what form is filed? So after obtaining name approval, we have to ensure that we have DSC, we have that DIN, because every member now will become, maybe if they are becoming the directors of the company, they also need to have DIN, right? So all these things we will ensure, and thereafter the filing has to be done along with URC1. There is going to be the member details like what, ma'am, names and address of whatever member, whoever is going to become the member of the company. In this case, there are 6 partners. All 6 can become the members of a private company. Now, of them, whoever wants to become the director, they also must have DIN. So the DIN also needs to be furnished with respect to the first director. So first director details also you will give. Thereafter, LLP agreement and certificate of registration. So LLP agreement and the registration certificate that you got. See, you have to remember one thing. When we incorporate LLP, when we form LLP agreement is not required at the time of incorporation. It may be furnished in E-Form 3 within 30 days of incorporation of LLP. However, now you are converting your LLP into a company, so you will definitely submit LLP agreement here itself. Okay, written consent of all the partners. You need to have obtained NOC from the creditors, NOC from ROC, copy of newspaper advertisement. Everything has to be furnished with this particular form. Thereafter, you will prepare MOA, AOA. You will submit it to the registrar of companies, and the process is done. The ROC will give you a new certificate of incorporation of being a company. Again, the answers that institute provide us, they do not give a conclusion. You have also been asked to recommend an appropriate decision. What appropriate decision you are recommending? You are recommending, since there are only 6 partners in the firm and you cannot form a public company with just 6 members. For forming a public company, you need to have at least 7 members. So this is not an advisable option, or this is not a feasible option. Hence, in the given situations, it is recommended that this LLP be converted into a private company by following the given procedure, and thereafter you will elaborate and write the entire procedure of conversion of LLP into a private company, right? Okay. I think the institute has also given you the conclusion. Right, right, right. Let's read the answer. Okay. No. A company with less than 7 members shall register as a private company, whether the majority is for a new corporate entity, the word public limited. Fine. So it tells us in such a manner that, okay, fine, a public company cannot be made. What I have told you, that simplifies the answer better. Okay. Moving to the next question. Appointment of first directors in case of government company. So very simple. You just have to write the entire procedure how government company appoints first directors. It is being appointed by CAG, right? So CAG will appoint the same. If CAG fails to appoint, then within this period of 60 days, the board is going to see first a government company is being formed within 60 days. CAG appoints the first auditor. If CAG fails to appoint within that 60 days of registration or incorporation of company, then the auditor is being appointed by the board within the next 30 days. However, if they also fail, then what is going to happen? The members are going to be called, and EGM is going to be held, and then within 60 days they appoint the auditor. So there are three persons who can appoint the auditor. First is CAG, second is the board, and third is the members. Okay, simple. Now 5B, the next part. Nature India Limited filed a petition under IBC with NCLT against Tulip Limited. So one company has filed an application against another company and petition was admitted. After that, they want to withdraw the petition based on the settlement arrived between the parties. Is it possible that you can withdraw the petition after it has been admitted, and also infer the legal provision relating to admission and rejection of application? So yes, of course it is possible. Yes, why not? The application, even if it is admitted, can be withdrawn. I differ with the given answer because this is the situation before, right? After the law has been amended, after we have a section called as section 12A, it permits the withdrawal of application. So even if you have a application for IBC or for application for CIRP has been filed by financial creditor, operational creditor under section 9, as this the case is, or maybe the corporate applicant, right? So it is filed by under section 7, 9 or 10, it doesn't matter. You can withdraw the application after you have filed the same. How can you withdraw the application? Ma'am, we can present it to NCLT and they will allow us. However, section 12A clearly says that application can be withdrawn or if 90% approval of COC is being obtained. So if you get that approval, thereafter you may inform the resolution professional and they will submit this petition for withdrawal of application, and adjudicating authority, that is NCLT, will allow that. However, if your committee of creditors have yet not been constituted, then what is going to happen? Then you will present it directly to the adjudicating authority and they may allow it, they may disallow it, right? Now, there are also a lot of case laws based on which we come to our conclusions. But here in the answer, ma'am, what should we write? Because if we look at the suggested answer, they are telling us something different. Will we get answer if we write just exactly this only? Well, see here. You must write. I cannot tell you to write an incorrect answer, of course. Mention about section 12A. Okay, so we have a section 12A. Of course, it is read with regulation also, the IBBI regulations that have been made. You have to write the content of section 12A, which talks about the withdrawal of application. This talks about withdrawal of application. Now, because ultimately our goal is to secure marks, and we have to be smart enough to not get into the dispute and the fights that what should happen, or this should happen, or this should not happen. How you must take action to present your answer. Write about this also. At the same time, what you will also write is according to suggested answer of the institute. According to suggested answer of the institute, not you need not write according to suggested answer. You will also write this. Okay, if this particular question comes in your examination, so mention about this and also write this. Fine. Okay, ma'am. Next, question number 6A, discuss the benefits of sustainable report. It is a straightforward question. No case study, nothing. You have to write everything that you have read about sustainability and its benefits, of course. So whatever you have read, that all everything has been reproduced over here, whether it actually directly relates or it doesn't matter. So whatever you have read about sustainable report or sustainability reporting, that has been reproduced over here, so you are going to do the same. Next comes your cyber crimes. So cyber crimes have been divided into three categories, right? So all the three categories, ma'am, we need to mention. The answer is yes, you need to mention all the three categories. So cyber crimes against persons which take place, cyber crimes against property, and also cyber crimes against government. Against persons, that means you could hack someone's phone, you could hack someone's email, internet, website, whatever it could be. You could defame someone, you could get unauthorized control or access over someone, you could stalk someone. Just like we stalk them in the physical space, we could also stalk them in a cyberspace. Cracking is what? Somebody has entered into your space and is trying to tamper or is trying to alter your confidential information, right? Then there could be spoofing also, right? Carding. What is carding? A lot of times these ATM cards or the debit cards or the credit cards, they are being used fraudulently. There could be a lot of fraud, there could be threat, like you have someone's video, you're trying to threaten that particular person, right? So we have discussed all these meanings with example in detail in the class. You have to don't write those examples, you don't have to elaborate every point. All that is needed over here in answers is that heading, cyber stalking, and one line defamation, and that one line. The same goes for property also. See, the property, we're not talking about the physical property. Nobody is entering into your physical property, they're all trying to enter into your cyberspace. Maybe your domain name, maybe trying to damage some of your property which is there available in the cyberspace. They're trying to hack some, they're entering into that cyberspace, so they are damaging your space. So it is your property that you have, in the software, the hardware that you have, that is your property, right? Some virus is entering, so what is happening? Your property is being destroyed. So there are some crimes against the property. Just like somebody could trespass your physical house, they could also trespass your cyberspace, right? So they could try to disturb you, they could try to damage some data, they could try to do a lot of things. So there are certain cyber crimes which we consider against property also, and thereafter the most important one, I would say, against the government, which is terrorism, warfare, piracy, and unauthorized information. Okay, fine, ma'am. Next, question number 7A, discuss connected person in context of insider trading. Of course, again a very important set of question, I would say. See, this concept prima facie relates to unpublished, price sensitive information, right? And that's why insider trading is being prohibited. And that's why we read about the SEBI regulation, SEBI prohibition of insider trading regulations. So, of course, anyone who has that unpublished price sensitive information, any person who has access to that, is stopped from disclosing it to anyone, right? And in such a case, we can reasonably expect that the persons who have UPSI, their connected persons are also assumed to have that UPSI. So they can also reasonably take advantage of the situation and thereafter demean the entire market scenario that is trying to be maintained by SEBI, right? So there are certain persons, according to the definition, who are deemed to be or who are considered to be connected persons. So these are certain persons who are deemed to be the connected persons. However, what is the prima facie definition which says that person who has during 6 months prior to whatever act or whatever transaction we are talking about has been directly or indirectly or in any communication, in a frequent communication is there, or directly indirectly you have been related, right? You have an employee relationship, you have a contractual relationship, you're a director, officer, employee of whatever company, so you are being considered to be the connected person, whether it's temporary or permanent, that allow you to have directly or indirectly access to unpublished price sensitive information, or you can reasonably be expected to have such access, right? The relatives, immediate relative of connected persons, they are also connected persons. The holding associate or subsidiary is the connected person. Any intermediary, right, as specified in section 12, or an employee or a director, they are connected person. Investment company trustee, AMC, employer, director, they are connected person. Official of stock exchange, they are connected person, because eventually there is the all the filing of documents are done, right? So they have that proper knowledge of every, maybe UPSI, they have reasonable access to all that information, right? So member of board of trustees of the mutual fund, right, or the asset management company, member of board of directors of PFI, public financial institution, from maybe whom we have taken a loan, so we provide them a lot of information about our financials and everything. Any official or an employee of self regulatory organization, whichever has been authorized by board, concerned firm, HUF, wherein director of the company or his immediate relative or banker has more than 10% of holding of interest. So of course I'm not going to explain you the entire point over here. It's just about recalling that what you have to state in the answer, what you don't have to state in the answer. So we're discussing about the MTP, right? So obviously in the definition of connected persons, you cannot skip any point, any single point you cannot skip, and it has to be more or less in the same language. So you cannot even alter the language because it will change the meaning. The words, the keywords, mostly are the keywords only. We don't have any unnecessary language associated with those keywords. So you have to write the entire thing. So you have been simply asked what is connected person, you have to write the entire definition, what is connected person. Thereafter, we come to again one very generic question and a very common, popular, old question, CCI. What is the duty and power of Director General of CCI? Okay. So, Director General is responsible for a number of duties: conducting investigations, gathering evidence, preparing reports, providing expert opinions, assisting CCI, prosecuting offences, competition advocacy, and thereafter they have certain powers as given in section 33, 34, 35. Right? Ma'am, we really need to write the entire thing, yes, and consider this question to be important also. Okay. Now, the last two questions, or the last question, I would say, we have question number 8. And see, as I told you, I was talking about this particular question only. In the question, they have asked about the role of RBI in management of foreign exchange, but in the suggested answer, they have written the entire history, geography, whatever they know about RBI and its role, they have written the entire thing. I have the, yes. See, inspection of banks. Okay, they regulate the commercial banks. They also take care of the AMC cell and all under PMLA, right? So they monitor the board level appointments in commercial banks. They grant license to the commercial banks, right? They formulate a lot of banking policies, they issue so many directives to the banks, they collect and disseminate information with respect to the assets, doubtful, lost, stressed, and all that, right? They oversee a lot of operations of banks. They authorize whether you can deal in about dealing in precious metals, that is golds and all, right? Even offshore banking units come under the purview of RBI only, right? Export credit policies, then granting a lot of exemptions. Here comes our role in FEMA. In FEMA, if why am I stopping over here now? In FEMA, there are prima facie two types of transactions. One is the current account transaction, other is the capital account transaction. The current account transactions are being regulated by central government. So central government has prescribed the rules for the same. When we come to capital account transactions, for capital account transactions, RBI has the power to actually tell what are the permissible capital account transactions, including the debt instruments. That power is also being given to RBI only. Thereafter, they can also impose conditions on the same, right? So, RBI under FEMA, properly, when we talk about foreign exchange management, they are the custodian of foreign exchange first. They regulate capital account transactions second. They control the dealing. A lot of times you need RBI approval for certain category of cases. Even when we talk about LRS, we have read in facilities other than individuals, you need to obtain RBI's approval in a lot of cases, even in current account transactions, right? So prima facie, RBI doesn't have the